Welcome to the Business Scholarship Podcast, a place for interdisciplinary conversations in the broad world of business research. My name is Andrew Jennings, and it's my pleasure to be your host. If you like what you hear today, please subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts. Plus, leave a rating and let other people know about the show too. And if you have ideas for the show, please let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. All right, time for the episode. Our guest today is James Ahn, teaching fellow in the Corporate Governance and Practice program and lecturer in law at Stanford Law School. We'll be discussing his new paper, The Direct Derivative Distinction in Shareholder Suits, which I'll link to in the show notes for the episode. Jim, welcome to the Business Scholarship Podcast.
Thanks, Andrew. Happy to be here.
Jim, as somebody who's taught a corporations class before, and I'm sure many listeners are current or former corporations teachers or future corporations teachers, I find myself when I read this article on the direct derivative divide in shareholder litigation, I find myself thinking about the way that I teach this topic in my class. And I might ask you to do me a big favor here and perhaps help me teach my class. I sometimes use these podcast episodes as teaching tools, and I understand some other professors around the country do as well. So perhaps if I want to use this podcast as a teaching tool, you've thought very deeply and originally about this distinction between derivative and direct shareholder litigation. I wonder if you could maybe present this topic at a high level for the listeners. First, perhaps, what's the role of shareholder lawsuits in corporate governance in broad relief? And let's maybe set aside shareholder securities litigation for the moment. So strictly focusing on corporate law, shareholder litigation. In broad relief, maybe present the two forms of shareholder lawsuits, direct and derivative litigation. What's the difference between these two, and why do the differences matter as a matter of corporate governance?
Shareholders have three main ways of holding managers accountable. They can vote their shares, they can sell their shares to somebody else, or they can sue. But with voting and selling, those methods are prospective. They don't allow shareholders to get compensation or redress for past misconduct. But on the other hand, when you sue, you can get compensation for past misconduct. Also, suing allows shareholders to seek redress for misconduct that interferes with their other rights. For instance, if managers interfere with shareholders' right to vote, shareholders can't just use their right to vote to fix that. That's the thing that's being interfered with to begin with. Instead, shareholders must sue to get redress. That's the real importance of shareholder litigation, is that it allows shareholders to get help when shareholders can't help themselves. Now, courts divide shareholder suits into two big groups, direct suits and derivative suits. Judges have regularly called the difference between direct and derivative suits outcome determinative and of critical importance. This is because derivative suits, while more common, are in many ways harder to bring than direct suits. Derivative suits involve a lot of hurdles that don't apply to direct suits. A complaint that's considered derivative will often be kicked out on these grounds, such as demand futility, and the complaining shareholder will be left without recourse. Okay, so I've said that direct suits are easy to bring and derivative suits are hard to bring, but I haven't explained which kinds of claims are considered derivative and which are direct. And that's actually a big part of the point I'm trying to make in my article. We don't have good ways to categorize claims as direct or derivative. As things are, one common categorization is that in a direct suit, a shareholder is bringing a claim on their own behalf and asserting a claim over rights that are held by the shareholder individually. While in a derivative suit, a shareholder is, in theory, bringing a claim on behalf of the corporation, asserting rights that are held by the corporation. But that doesn't necessarily tell you much. For example, directors' fiduciary duties generally run to both the corporation and to shareholders individually. So if you're asserting a breach of fiduciary duty, are you suing on your own behalf or on behalf of the corporation? Courts have come up with some tests, namely the Tooley test, to figure this out, but there are some problems with those, as I'm sure we'll talk about. That said, there are some areas of common ground between my view and what various courts have said about what direct claims are and what derivative claims are. I think we all agree that direct claims cover things such as violations of shareholder voting rights or information rights such as books and records. And derivative suits cover things such as garden variety mismanagement, for example. If Blockbuster's board decided not to invest in Netflix, and that turns out to be a really bad business decision, a breach of fiduciary duty claim against the board by a shareholder should be treated as a derivative claim.
Thanks for that overview of the received learning around the direct derivative distinction. And I think you challenge that distinction in this paper and will in this interview. But as this has been a distinction that's presented in a pretty simple, straightforward way, but it's deceptively simple, it's deceptively straightforward, and that lawyers, law students, dare I say, even corporate law judges have really struggled with this distinction over the years. Could you talk a little bit about why this distinction has been such a difficult concept for legal practitioners and judges to reach some coherent understanding around?
I have several good quotes in my article about what people have said about this distinction. These are quotes from judicial opinions and law review articles. They've called it difficult, challenging, confusing, complex, easily muddled, fuzzy, slippery, highly subjective, unpredictable, elusive, and incredibly opaque. You can go to my article and find the sites for these. But yeah, this is something that people have really said, wow, why is this thing that's seemingly simple actually really difficult and complex? One problem is this. Given the different procedural hurdles that apply to the two types of claims, there are some claims that, as a policy matter, courts want to treat one way and apply lower hurdles, say. But then there are other similar-looking claims that, as a policy matter, courts want to treat the opposite way, apply higher hurdles, say. For example, suppose a corporation hires a CEO and a question arises as to how a cash bonus should be calculated under the employment agreement. This is probably something that should be handled by the board, not by some shareholder who thinks that they know better. And so even though the amount of the bonus might affect the value of the shareholder's shares, if a shareholder has some complaint that the bonus is calculated incorrectly, that shareholder has to bring the claim derivatively and should bring the claim derivatively. Otherwise, a shareholder could easily drag this dispute into the courts, even though it really shouldn't be there, because the board can resolve it much more efficiently. And you can see how if these cases were allowed into the courts, how bad actors could abuse the process. Shareholders could just sue for the holdup value of the case and demand settlements at the expense of every other shareholder. Okay, so that's the case with a cash bonus. The policy says, let's keep it out of the courts. But what if the CEO is getting paid with stock and stock options? What if instead of a dispute over whether the CEO gets $1 or $2 million, the dispute is over whether the CEO gets 1 or 2 million shares? Now, traditionally, claims over the actual shares of stock are often considered direct. For example, suppose you own 100 shares in a corporation and the corporation just cancels half your shares. No reason, no compensation. Traditionally, and I think even now, the courts would consider that to give rise to a direct claim because the shares belong to the shareholders individually, and the injury to the shareholder doesn't arise derivatively out of some injury to the corporation. Likewise, the board, who's ordinarily empowered to bring claims on behalf of the corporation, isn't necessarily going to care about some problem that affects a single shareholder in this case, and frankly benefits the other shareholders who now own a greater relative stake if one shareholder, but not any other shareholder, has their shares canceled. But if you give a CEO equity compensation, that's also diluting the economic stake of other shareholders. Other shareholders effectively own less of the corporation because of the equity compensation. In some ways, it's an economic equivalent of canceling a fraction of a share that every other shareholder holds. Should the CEO stock compensation case be considered direct or derivative? For good reason, you might think it's pretty much like the cash compensation case, so it should be a derivative suit. But at the same time, it involves stock, which traditionally has given rise to direct suits in many cases, also for good reason. A related problem is that I would say many, if not most areas of corporate law aren't really all that formalistic. The courts just look at things more closely if it falls into certain very generally drawn transactional categories. Judicial scrutiny doesn't depend on and shouldn't depend on creative deal structuring. There's a good quote from Schnell versus Chris-Craft that I'm sure many of your listeners are familiar with. And the quote goes, "Inequitable action does not become permissible simply because it is legally possible." But here for the direct derivative distinction, courts seem to be frequently coming up with a nice, clean, formalistic test. And courts have been lured into thinking that a formalistic approach will create fair outcomes. But it's really hard to rest upon formalism when at the end of the day, the corporation is just a legal fiction. There are other entities and human individuals behind the corporation. And importantly, creative lawyering can get around any formalistic lines that are too narrowly enforced. I certainly understand the appeal of trying to use formalism. An earlier version of my article took a formalistic approach. But after I wrote this amicus brief before the Delaware Supreme Court, arguing against formalism in another context, I realized that too formalistic of an approach here also won't get you to a consistent, fair result.
Could you talk about why it matters that we have this sort of muddle in understanding the distinction or drawing distinctions between direct and derivative litigation? What are the perhaps political, economic, or real-world consequences for the courts, for litigants, for corporate America and corporate governance? Why is this an issue that matters for the real world?
At the end of the day, I think the reason why this matters, why this is of, quote, critical importance, is because it's outcome determinative. If you have a case that's treated as derivative, there's a good chance it gets dismissed. So you got to get the distinction right, because otherwise there can be unfair dealings that the courts will have trouble resolving, that the courts will not give adequate redress for. If you get it wrong, there will be bad actors out there who will engage in harmful conduct, and shareholders can't do anything about it. And everyone loses in the long run when that happens. The shareholders don't invest, entrepreneurs can't get investment. You end up with the market for lemons. We lose as an economy, as a society, when courts can't make sure everything is fair. So that's why this is ultimately important.
You mentioned an important Delaware case that stands for the current doctrine, the Tooley case, and the Tooley test that is derived from that case. And that's a big focus of your article. So I wonder if you could talk to us a little bit about Tooley's doctrine and the Tooley test, and what deficiencies you identify in Tooley and how you propose perhaps address or fix some of those deficiencies.
The Tooley test asks this. 1, who suffered the alleged harm, the corporation or the suing shareholders individually? And 2, who would receive the benefit of any recovery or other remedy, the corporation or the shareholders individually? The problem is that the answers to both of these questions can be manipulated pretty easily. I'll give you some examples from my article. Consider a corporation X, which has an equity value of $10 million, half of which is held by a controlling shareholder and the other half of which is held by a number of dispersed minority shareholders. Now, consider 3 potential conflict transactions. I'll tell you now, in all 3 transactions, the point is to end up with $10 million in equity value, but instead of 50-50, 60% of it is going to be held by the controller and 40% by the minority. In transaction 1, the way the controller does this is that he causes Corporation X to pay $2 million for a worthless asset that the controller themselves own, and then using those $2 million in proceeds, the controller buys another $2 million worth of shares from the corporation at fair market value. In transaction 2, the controller causes Corporation X to just issue additional shares to themselves for zero consideration, such that the controller owns 60% of the corporation's outstanding shares afterwards. Under Tooley, both of these first 2 transactions result in what Tooley considers to be corporate injuries. The controller supposedly underpaid for something from the corporation, and only derivative claims are available. So now let's go to transaction 3. In transaction 3, the controller causes the corporation to cancel some of the minority shares so that the controller holds 60% of Corporation X's outstanding shares afterwards. Here, however, the minority shareholders probably can bring a direct suit because their shares were just canceled without any effect on the corporation. But really, as I said at the beginning, these transactions are economically identical. The controller starts with 50% of a $10 million company and ends with 60%. So why are the legal claims available different under Tooley? You can also look at the second prong of Tooley, the benefit of any recovery prong. Vice Chancellor Laster of the Delaware Court of Chancery has already written about this in some of his opinions. Basically, which legal entity receives a recovery is chosen by the court, and there are multiple ways to have a fair remedy. For example, suppose a controlled corporation issues additional shares to the controller for inadequate consideration. One arguably equitable remedy may be that the controller is ordered to pay to the corporation the difference between the pre-transaction fair market value of those shares and the amount actually paid. And that suggests that the claim is derivative because the corporation receives the recovery. But other equitable remedies might be that the wrongfully issued shares are just canceled, or that each minority shareholder receive additional shares for each share that they previously held, the same way that the controller did, or that the controller directly pay each minority shareholder for their economic losses. And those remedies that go directly to the shareholders suggest that the claim is direct. And that's the basic problem with Thule. It draws formalistic lines to determine which claims should be direct and which should be derivative, but those lines can be manipulated, not the least by transactional attorneys. So what would I propose instead? To answer that, before anything else, I think we need to think about the really real distinction between direct and derivative claims. And what's the really real distinction? I would say that the really real distinction is the outcome of making the distinction. Direct claims are claims that are relatively easy to bring, and derivative claims are claims that are relatively hard to bring. And then we can ask, okay, so which claims should be easy to bring? Which claims should be hard to bring? And I would answer that with two prongs. Frankly, courts have implicitly thought about these things already. First, as we talked about right at the beginning, shareholders have rights other than bringing lawsuits to rein in managers. Are those rights in danger, or can those rights help resolve the dispute? Second, courts have strengths and weaknesses. One weakness that courts like to remind us of is that courts are not good at second-guessing genuine business decisions. Decisions such as, do we expand to Asia first or Europe first? How much to pay a CEO? But a strength of courts is that they might be comparatively good at evaluating matters of process and procedure. Lawyers love procedure, after all. And if you consider those two prongs, what you end up with when you try to determine the direct or derivative nature of a claim is first ask whether special procedural rights are at stake. Are the other ways in which shareholders can hold management accountable at stake? For example, voting. If a board is making bad business decisions, shareholders can vote them out. But if the right to vote itself is threatened, then obviously, as I mentioned, shareholders can't just vote out the board. They have to do something else. They have to go to the courts. Claims like that maybe should have easier access to the courts by being treated as direct claims rather than derivative claims. Second, you end up with asking, is there disproportionate injury where the injured party can't use their other governance rights, again, such as voting, to protect themselves? For example, if only one small shareholder has their shares canceled, the other shareholders probably won't care, and thus there's good reason that the board won't care. Likewise, if there's a controller and the controller abused their control rights to take advantage, the minority can't just vote in a new board to fix that or to seek redress. The controller, by definition, gets to choose who sits on the board. And this helps us solve the CEO pay dilemma from earlier. The reason why I would say stock compensation ordinarily should give rise only to derivative claims is because an elected board is generally going to be perfectly capable of solving that issue. Even if shareholders disagree with the outcome, they can vote in a board who approaches compensation in the way that they prefer.
You're advocating or you're proposing a different approach that perhaps solves some of the muddle, the thicket around the derivative direct distinction. If the Delaware Supreme Court or if other state Supreme Courts were to adopt your approach, could you talk about the effect that might have in the world? How is the world different? And is it different in good ways? Is it a better world perhaps than we have today?
I certainly hope so. I think one thing we agree on is that the current approach is really muddled. We have all these quotes calling it difficult, challenging, confusing, complex, incredibly opaque, so on. If my approach is less of all of that, and I think it is, then I think it makes things easier for the courts. It makes things easier for the parties. And if that's the case, then it should make business less costly because there will be hopefully less litigation. And the litigation that does remain will go more quickly and smoothly. Also, I think under the current system, you have some abuses that aren't being adequately addressed because the claims are being considered derivative, when maybe they should be considered direct. You have cases where A controller uses their power to engage in unfair transactions that are structured as stock issuances, and that's treated as a so-called dilution claim, which in turn are treated as derivative. But these cases, their economics aren't really all that different from that of a squeeze-out merger, where the shareholders would be able to bring a direct claim. Likewise, consider something like golden parachutes. Suppose management demands a $100 million bribe from an acquirer to ease along a merger sale. The Parnes decision said that's direct because shareholders would have otherwise received that amount in a sale. However, suppose management instead causes the corporation to enter into employment contracts that pay $100 million in bonuses to all the managers upon the sale of the corporation, and then they close the sale. The Lewis and Kramer decisions said that claims arising out of that conduct are derivative because those funds came from the corporation. But what's the real difference between management saying any acquirer has to pay us $100 million for us to agree to a deal, and we're giving ourselves contracts where if any acquirer buys us, we get $100 million? I think those are basically economically the same, and legally they should be treated similarly. If you're treating them differently, that's going to lead to abuse from creative deal structuring and ultimately higher transaction costs as managers spend on lawyers to get around the rules, and less predictability because investors aren't going to know what managers are going to be able to get away with, and overall, a less efficient system.
Are there any key takeaways you'd like listeners of this interview or readers of the paper to have? And you're early in your academic and scholarly career, so I wonder if there are any kind of open research questions that perhaps this paper and some of your work with an amicus brief have generated that you might pursue in the future.
This is an important question. This is a question that helps decide whether shareholders can receive redress for management misconduct. But it's also a question that helps protect corporations and their shareholders from frivolous lawsuits. But it's not an easy question. The amicus brief I wrote that I mentioned caused me to revise this paper substantially. And so I think I approached this question with a sense of humility. I might have missed something. I certainly missed something my first time around. Even if I'm right, I can certainly appreciate why courts have gotten it wrong. I got it wrong. I think I got it right this time, but maybe I didn't. If people read my paper and say, hey, you missed something, I want to be open to that and say, okay, let me take a look. I think this is a difficult question, and it's understandable why. Those are what I think are the key takeaways. This is an important question, and it's a hard question. But it's a question where I think a better answer can make things more efficient and more just for everyone involved.
Our guest today has been James Ahn, teaching fellow in the Corporate Governance and Practice program and lecturer in law at Stanford Law School. We've discussed his new paper, The Direct Derivative Distinction in Shareholder Suits, which I'll link to in the show notes for the episode. Jim, thank you for joining the Business Scholarship Podcast.
Thank you, Andrew.
Thank you for listening to another episode of the Business Scholarship Podcast. If you like what you heard today, be sure to subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts, rate the show, and let other people know about it too. If you have ideas for future episodes, let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. Until the next time, I'm your host, Andrew Jennings.